position makes it pretty easy to get around patent protection, doesn't it? All you've got to do is find one step in the process and essentially outsource it or make it attractive for someone else to perform that particular step, and you've essentially invalidated the patent.
I don't think so, Your Honor, in the following in two following senses. First of all, empirically speaking, there have not been very many cases in which this has proven to be a problem. It has been a long understood principle of patent claim drafting that method claims should be drafted from the point of view of a potential infringer so that all of the steps can be carried out by that potential infringer. And prospectively, certainly, and given that this rule has been clearly articulated by the Federal Circuit now for many years, or at least several years, prospectively, the patent applicant has every incentive to draft claims from the point of view of a single potential infringer. The claim that's at issue here, there's no dispute. It could have been written in such a way that the steps would have been carried out by a single infringer, and indeed that may have been the intent. What the inventor had in mind may well have been.
When you say it would be written that way, it would be by not claiming one step in the method, I assume, which changes the whole patent.
Well, it would be to claim what is carried out from the point of view of the potential infringer. So, for example, in this case, what the method claim could have been written to say, rather than to tag an embedded object, to deliver an embedded object in response to a request for that object where in the request.
But you don't know really in every patent whether the tagging is an important part of the process or not.
Well, by definition, Your Honor, every step is material and important to the invention. That is really very deeply ingrained in the patent law.
Federal Circuit's ruling and say it makes no sense. How can you induce infringement if there's no infringement in the first place? And that's a very strong argument. But the reason they put this under 271B rather than under 271A is because of what Justice Scalia said. The 271B is not a strict liability offense. And so that you can say you have to know and you have to have instructed the person. So, they thought that they were being very clever by putting it into a 271B box and avoiding the strict liability consequences of what they were doing, but also avoiding the possibility of an end run of the patent law.
I think that's right. I think another reason the Federal Circuit might not want to.
And also avoiding the text of the statute.
There is that problem. There is that problem.
Right. I think the problem under 271A for the Federal Circuit was that well-established tort doctrines don't support attribution liability when you have a vendor customer. So it turned to 271B. The problem with 271B, as Justice Scalia said, is that it's very clear from the text of the statute that the conduct induced has to be direct infringement. And I think the Court has twice before confronted situations where there was conduct that clearly was intended to circumvent the Patent Act. In both Microsoft versus AT&T and Deep South, it was very clear that what the defendant was trying to do was ship operations overseas so that it could avoid the Patent Act. And in both of those cases, the Court reversed lower court decisions that had used that desire to stop circumvention as the primary driver of its interpretation of the Act. So in both cases, the Court said, to be liable under 271, you have to satisfy the requirements of 271. We are not going to interpret the text simply to avoid circumvention concerns, even when, you would say if you were looking from the perspective of the patentee that essentially their patent had been performed. In both cases, the Court said it is for Congress to make that judgment because there will always be countervailing policy concerns.
Infringement without an infringer.
You can certainly have infringement without an actionable infringer. Absolutely. Under anybody's rule, you can do that. The whole debate we have with the other side on the A question is what attribution rules do or don't apply. But if you have an example, to take Justice, one of the things that's one small part of what's bothering Justice Breyer, you have a situation where however many steps there are and however many parties there are some parties that don't know about each other or what they're doing. In those circumstances, the common law doesn't apply liability, and therefore you would have an instance in which there could be an infringement under 154.1 in the sense that all of the steps of the patented method are performed, but there will be no liability because the performers were not acting in concert or at the direction or control of each other. And that's why I think what the Federal Circuit did on its own terms is not novel. It accepted the proposition that you can't have inducement liability unless there is an infringement, unless there is a tort.